Gentleman yields.
Chairman Murr, there's been a lot of discussion about the fact that apparently some of this testimony was not sworn to under oath. Do you recall all those statements that have been made in the questions and answers?
Yes, I recall.
All right. And are you familiar with the whistleblower suit, the petition itself, filed by James Blake Brickman, David Maxwell, J. Mark Penley, and Ryan M. Vassar?
Yes, we've been referring to that since the beginning of our discussions today, and obviously that was a hot topic back in February whenever the parties requested the state to fund a proposed $3.3 million settlement.
And my review of that petition, and I've read the petition, is after page 65. It's about 120-something page petition, including attachments. But after page 65, it has several declarations. Mr. Brickman, Mr. Maxwell, all the plaintiffs in the case have each signed a statement and verification. Do you recall that?
Yes, I do.
All right. And in fact, each one of those statements, and I'm looking at it here now, refers to different paragraphs where certain facts are alleged and says that those matters are in their personal knowledge and that each and every one of those things is true and correct. Do you recall that?
Yes.
All right. As a matter of fact, they go on to say that they state those things under penalty of perjury that they are true and correct. Is that correct?
Yes, there were documents both from that litigation and then, if I recall correctly, documents from the litigation involving the Mitty Foundation, in which depositions were made, including that of Mr. Nate Paul. So there have been multiple documents that have been reviewed that are either transcripts or signed under oath whenever folks talk about that process.
And I think you mentioned that there was deposition testimony of Nate Paul that was contained and referred to in the materials that we've received.
Yes, that is correct.
All right. And to characterize this as saying that none of the information, none of the statements were sworn to or verified, would you say that that is a misstatement?
Yes, I would say that's a misstatement, and I would also add that there is nothing in the House rules, in statute, or in the Constitution pursuant to these proceedings that we have to go get sworn testimony in the House as far as the investigation into any allegations of wrongdoing. That is not what is required. That is not necessarily what law enforcement does whenever we equate this to a process, even though it is not criminal in nature. But we've talked about this concept that the House serves similarly like a grand jury. So the House itself receives information, and even Mr. Smithy made a point earlier that that level of information is going to be different than what would be admissible at trial. And here, trial does not occur in the House. Trial occurs in the Senate. And in the Senate, presumably rules of evidence would be required. Witnesses would be subpoenaed or voluntarily show up, and they would have to be under oath. So we have gathered a lot of information. Now, some of the witnesses that were sought out and interviewed as part of our process were done so pursuant to subpoenas that the committee issued. No witness sought to quash those subpoenas. There's methods out there to say, hey, I don't want to do this. So those subpoenas came in and they willingly sat down once they received a subpoena and testified. And then the final thing that I will point out, as part as the committee's work and the efforts that we undertake, is that we have to be conscientious that if the committee requests someone to come testify and they raise an issue that say that if I provide testimony or produce a document and I think that violates, essentially a Fifth Amendment right and will get me in hot water, then we can still compel them to testify or produce, and they will receive immunity. And that essentially is immunity from prosecution of state law. And so we have to be conscientious and careful about what the committee does, or we wield an immunity power.
So to recap some of this about the sworn testimony, these individuals, and I think that you've already attested to it, as well as some others previously today, have talked about these four people were some of the top people at the Office of the Attorney General, correct?
Yes, that's right. I think folks are forgetting the fact that division chiefs, these are people who help run one of the most important agencies in the state of Texas. They identified wrongdoing, they reported it to law enforcement, and they were fired. They had a lawsuit against their boss, and they did provide sworn statements in that lawsuit. In addition to that, either through a subpoena or at our request, they sat down and spoke with their attorneys present, with our investigators, and our investigators and attorneys downloaded that information to us. The full expectation here is each one of these people that sat down and helped us gather information is expected to testify at trial under oath. Yes.
So much of the relevant portions of what we've covered today, as far as the allegations, all of those have been sworn to by each of these individuals that are listed as plaintiffs in this suit. Is that correct?
That is correct. Yes, sir.
Right. And let me ask you this, with regard to your understanding from visiting with the investigators that this committee retained, is it your understanding that all of the testimony that was gathered and received, because many times in an investigation you'll have, maybe somebody recalls something slightly different, or there may be slight differences of recollection of facts, but do you know of any pertinent facts, relevant facts that apply in this instance from any of the witnesses that did not fall completely in line together with the testimony of each witness that the group sought testimony from?
Emphatically no. Importantly, we ask our investigating attorneys, did you find variations whenever you went out and sought these facts? They said no. They all interlock. They all corroborate each other. They're all accurate. Whether it is statements made in litigation previously or the fact that they were interviewed separately and it come to find out that they all had a common recollection of facts. And that indicates that they're accurate statements. We would rely upon that when we present it to this body to say, we're asking you to consider sending it to trial in the Senate, and we expect those people to show up and offer their testimony under oath there.
And also, Chairman, with regard to each of these individuals signing under penalty of perjury, you understand that perjury is a criminal offense and is a felony criminal offense punishable by confinement in the penitentiary.
That is correct.
All right. Thank you.
Yes.